Good afternoon. This is Deputy Chief Judge Dave Langham with the Office of Judges of Compensation Claims, and we're here this afternoon for a continuing education program on mediation and its trials and tribulations. I'm joined today by Judge Edward Almeida from the Miami District Office. Judge Almeida has practiced in every aspect of workers' comp and has a long experience as a mediator before taking the bench. Just under him in our array here is Mediator Eric of the Miami District Office. And she likewise has practiced in workers' comp from various aspects, claimants, defense, and now mediating, and has been with us there in the Miami District Office for several years. And just under her on the array is a retired Judge Charles Hill, who was with us in the Miami office for a number of years and has since began a practice in private mediation, I think primarily in South Florida, but probably would take on any case that was brought to him. So what we're going to work on today is essentially what these three mediators, former mediators, see as the current topics that are troubling or challenging in mediation. And I'm going to go first to Judge Hill. Judge, what do you see as the important guidelines or the important ethical concerns or boundaries for mediators in today's practice?
Well, they certainly are numerous. And of course, our discussion today will be primarily focused upon ethics. And we have various guidelines to refer to. Ethics has its tentacles in all we do as lawyers and as mediators, state as well as private. There is not a topic governing our behavior untouched. Private mediators are bound to abide by the Florida rules for certified and court-appointed mediators, set forth in 3 parts. They're set forth by the ADR, the Alternate Dispute Resolution Center in Tallahassee. The first section is qualifications, which we won't be dealing with today. The second section is standards of professional conduct, and which will be our primary focus today. And 3 is discipline, which establishes under Rule 10.900 a mediator ethics advisory committee. That's a mouthful. And it's abbreviated in short to MEAC, MEAC. It sounds a little frightening if you think you might have a MEAC. But at any rate, it provides written advisory opinions to ethical questions arising from the standards of professional conduct. We will address a few of those advisory opinions as they apply to workers' compensation matters. These standards involve the mediator's responsibilities to honor the parties' rights to, this is important, self-determination, to act with impartiality, to avoid coercion, to avoid improper influences, and avoid, of course, conflicts of interest. And those are sometimes referred to as filters when the advisory committee will go through a question and they might they'll bring up the different points there and then apply these standards. And they'll say, well, we're going to apply this filter and that filter, and they'll give you the number of the rule, etc. In addition to the above ADR rules, mediators are also bound by the rules of procedure for workers' compensation adjudications. And as we all know, that's found under Chapter 60Q-6.110-6.112. Of interest is Rule 6.110, subparagraph 1D, is failure to appear at a, quote, voluntary mediation shall not be a basis for sanctions. 5, any party appearing by telephone has stipulated to be bound by that party's attorney of record's signature on the mediation report. under 5B of that rule, if a person attends telephonically, he or she must provide an email address to exchange documents. And telephone mediation is not concluded until the mediator's report is returned to the mediator. Subparagraph 7, in an open JCC case, the mediator shall prepare a report stating which issues are resolved, which are remaining unresolved, and note whether a pretrial step has been completed, and ID each PFB, petition for benefits, by date mediated. Also, in addition to the foregoing rules, we have Florida Statute 440.25, and that governs aspects of the mediation process for us. Subparagraph 3B provides if both parties agree to the results of the mediation conference, it shall be binding without a right to appeal. Also provides if either party does not agree with the result of the conference, the result, the witnesses, the testimony, the evidence adduced at the conference shall not be admissible on any future proceeding on the claim. Now, of particular interest, the mediator shall not be called in to testify or give deposition to resolve any claim for any hearing before the JCC. Note this refers to any claim, and claims are defined under 60Q-6.102 as each assertion of a legal right or benefit under Chapter 440. Any right under Chapter 440 would include, in my opinion, a motion to enforce the settlement. These rules and statutes provide a framework to promote and to assure adherence to professional conduct by the, by the mediator. So let's turn to some of the MEAC advisory opinions and the standards. You'll see that often overlap and intertwine and are. I'm going to turn down this light because I'm getting a glare. Don't worry, I have on no shorts. Pants. There we go. That should help. Okay, we were discussing how the framework promotes and assures professional conduct by the mediator. And that we're going to turn now to some of the MEAC advisory opinions. And these standards often overlap and intertwine and are set up as questions and advisory answers. To the best of my knowledge, as I went through them, I did not find any workers' compensation matters addressed specifically. The concepts, though, are all inclusive. The opinions are numbered first by the year and then with the sequential number affixed. Okay, so that should give us an overall idea of how we're going to be addressing the mediator ethics at this point and the things that we'll be referencing. All right, I'd like to turn this over then, I guess, and I'll go back to my outline.
I think I'm next in line, but
Yeah.
I had a question. For those that are watching this video, you're referring to the MEAC opinions. Where would a practitioner find those so they can educate themselves?
Well, what I do, I put in through Chrome, I put in Mediator Advisory Ethics Committee -Florida. Push that button and up it comes.
So
And as it,
they're online, they're accessible.
they're online, they're quickly accessible.
And they're sorted by advisory opinions, MEAC opinions. They're sorted by confidentiality versus ethics versus procedure. I think there's a category. Not a very extensive ability to guide you through it as a digest, but it does give you some breakdown. And they're all available to be.
And they will encapsulate what the opinions are about if you want to discuss or look for impartiality or self-determination. You can, there's a little box there that you can punch that one, and it'll bring you those particular MEAC opinions. They go all the way back to 1995, at which time they were called mediator qualifications advisory panels. So we've gone from a panel to a committee. And no more qualifications, I guess.
So I think Judge Almeida, you were going to cover,
I'm doing item number 2.
there you go, right.
This particular item and the subsections that are included therein dovetail not only ethics of the mediator, but also the procedural aspects involving the mediations that when they come before a judge. And just as a background, in the years that I was a state mediator was 7 years, and then as a judge until the COVID pandemic hit, there were very few motions to enforce settlements or mediations agreement. It seems to have now become perhaps not a pandemic, but more and more motions are filed where a party who attended the mediation by phone is disputing it. So here we dovetail ethics and as well as the law. As stated in number 1, the motion obviously has to be in writing and request a relief. Now, I have seen as a judge objections to the motion when they attach the mediation agreement as part of the basis for it. And they say the mediation agreement is confidential or privileged. Well, it is not. The Florida statute 44.405, paren 4, paren A, paren 1, specifically expresses that the agreement itself is not confidential once it's been executed by the parties. And it then essentially becomes a contract of the parties. So that's the first obstacle that.
We lost your audio.
Can you hear me now?
You're back. Oh, you're not.
Okay, I don't know where did I get lost. I was citing the statute. The statute put in.
You're coming through very soft, Judge.
Okay.
There you are.
Statute number 44.405, paren 4, paren A, paren 1. And that specifically provides that the mediation agreement, once it's been executed by the parties, is no longer a confidential document. In essence, it becomes the contract of the parties as any other contract. But now we have to get to the problem of the execution of the agreement. And we have here conflicting statutes between the workers' compensation and as well as then the general litigation. In the general litigation rule 1.730, parentheses B as in Bravo, parentheses 1, the mediation agreement is not binding unless executed by the parties. And the parties are defined as the plaintiff and the defendant. There's 2 cases that are applicable, and I don't think that they would apply to workers' comp because workers' comp has its own rule, but I will give you the citation. And the first case is Gordon versus Royal Caribbean, 641 Southern 2nd, 515. And in that case, the attorney signed on behalf of the client. In fact, in the presence of the client, there was a motion to enforce, and the court held that the signature of the parties is necessary, and just the signature of the attorney, even in this circumstance, is wholly insufficient. There was a variation of this theme in the case of Jordan versus Adventist Health, 656 Southern 2nd, 200. And in that particular case, the parties signed the agreement, but for some reason, the attorney for one of the parties didn't get to sign it. On the motion to enforce, the court granted it and said that while the statute or the rule requires that, the fact that the attorney didn't sign it when the party signed it was just, quote, just a technical detail, and they enforced it. And that's the first thing to consider is the agreement itself, and then obviously signed by whom. This brings the problem of the mediator being called to testify, which I have seen on numerous occasions when there is particularly a problem that the claimant has disputing the fact that they made an agreement. And obviously, if the claimant is live in presence and they sign the agreement, is one thing. But oftentimes now, this is just done remotely with one signature by an attorney. And I personally go by the Florida statute. And the Florida statute is very clear, 440-25, that the mediator shall not testify or give a deposition. And I mean, that is absolute in my case, at least in my view. Now, in the years that I have been in the bench, and then prior to that, as a mediator, which was 7 years as a state mediator, I have spoken to judges, and there seems to be a variation of opinion. And some judges are of the opinion that while the mediator cannot testify as to anything of substance, they can testify as to a matter of procedure. For instance, did somebody show up, or were they by phone, or were they live? And this is going to be, obviously, because of the language of the statute, up to the judge. I guess the next section is yours.
Right.
Yeah.
Mediator Susan Eric is going to come in at this point.
Oh, we're going to talk about a few
And
things.
there appears to be a little bit of overlap into what Judge Almeida had to say.
There is. So in addition to the mediation agreement, we have an obligation to file our conference reports. And that brings a few questions. One is, we see in the state mediators, we all sign our mediation agreements, whereas very often a private mediator doesn't. Well, in fact is that according to the MEAC opinions, we really have no obligation to sign the agreement. And the only purpose of that signature really is to identify that you did conduct that mediation, which is what our conference reports also reflect and indicate. The necessity of the signature, I think, is form over substance at the you understand that the purpose of your signature is to confirm that you conducted the mediation, not that you witnessed the mediation or are in any way subjecting yourself to be a witness, as Judge Almeida was referring to. The other point is that I was going to cover is conference reports. And I know we in the state mediators have discussed it ourselves, and it's something really very important, I think, to be reminded. Our conference reports go on the docket, as our mediation agreements do. Our conference reports are intended to convey to our judges limited information. That is, parties appeared and they reached an agreement, and it's in our attached mediation agreement, or the parties appeared and they did not reach an agreement and they impassed, or the parties appeared and they reached a partial agreement and the remainder is at issue. And we list that petition. That is all a conference report should contain. Not that an agreement was reached and nobody signed it, not that parties didn't come to the with a authority to settle the case. Nothing else is to be conveyed. There's no reason to, that's not our job. Conference report to be a little cleaned up, I think, and we see a lot of extra information on them not be listed. I also was going to cover the point of, we as state mediators so very often have, well, too often, not so often, but too often have situations where we get a call, an email, that the parties aren't going to reach an agreement. We've already discussed it. We just want an impasse. That's standard. Not only is it improper, we're required to hold our mediation, but by the MEAC rules, we're required to at least convene and orient the parties as to what the process is about. And in that opening, in that description, it does give a mediator the opportunity to suggest some potential inroads, as opposed to just walking away without any discussion. If the parties, after you've given them your opening and you've explained this, insisted they want to impasse, well, then they can have their impasse. If you think, however, that it's just a matter of, a bad day and the parties should come back on another day to discuss this in a better mood, or we have no authority to require anybody to reconvene or come back at a subsequent time unless all of the parties agree to that. Some of the things that we're finding in, I know that you all wanted me to cover another topic too. Let's see, figure out which it is. It's under the MEAC. I think that was covering really signing the agreement, conference report, confidentiality. Of course, our mediations begin